Lee, will you be taking this witness or Ms. Schuman?
That would be Ms. Schuman.
Perfect, thank you. Good morning, Justice Birch. Before you have a seat, if you would please raise your right hand and I will swear you in. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat. And once you get settled, just pull the microphone sort of uncomfortably close because we're recording and amplifying for sound. I see you've brought water, but there's a fresh bottle in front of you. And to your right are binders containing exhibits that the lawyers may ask you questions about, but they will help you locate the exhibit if they do that. Ms. Schuman, you may proceed.
Good morning, and I promise I'm only going to reference one, and I've laid it out for you to try to make it easy. Justice Birch, would you please introduce yourself to the panel?
Sure. My name is Rebecca White Birch. You want more detail?
I do, but let's start with, I refer the hearing panel to Exhibit 114, which I've laid out right next to you, ma'am. It's at Bates 3874-3881.
Oh, yes, I recognize this.
And what is that?
This is a copy of a roughly reconstituted resume that I put together a while back when I realized that when I left the court I didn't have my full one.
And that's all. I just wanted you to identify that. So let's just talk generally about your vast experience. So what was your position with the Arizona Supreme Court? Let's work backwards.
I was a justice for just over 13 years. I was on the Court of Appeals before that. I served as Chief Justice from 2009 to 2014. In that capacity, we oversaw lawyer and judge discipline. In addition to that, I served on the Judicial Ethics Advisory Committee. I chaired the committee that revamped the State Bar and created the new Judicial Ethics Advisory Committee. I've served on numerous task forces, chaired them, served as a member, and actually formed various committees dealing with access to justice. I've authored law review articles in the field of professional responsibility. Mostly those were during my law teaching days. I was the Chief Justice when we decided to revamp the judicial discipline system. I could go on.
Meaning the system that we're just now in the middle of was something that you helped create.
This system that created the Office of the Presiding Disciplinary Judge that uses a probable cause panel as opposed to having an executive from the State Bar on an annual basis determine probable cause.
Can I just clarify, because I think on a couple of occasions you called it the judicial discipline system, and I think lawyer discipline system is maybe...
I'm sorry. Yes, thank you. I worked on both, and but we're talking specifically at this point, of course, about the lawyer discipline system. Thank you, Judge.
Did you participate in any cases while you were with the Arizona Supreme Court that dealt with prosecutorial misconduct?
It was an aspect of several of the capital cases that we tried.
Were you involved with Peasley, for example?
Peasley was before the court. Ford was before the court. Ham and King, but those weren't really prosecutorial misconduct cases. There were various cases before the court dealing with lawyer misconduct. Some of them simply dealt with the issue of whether the misconduct should warrant a new trial. So it was a slightly different aspect of lawyer misconduct.
Were you also involved in the review of cases involving actual ethical misconduct by attorneys?
Yes.
Okay. So how would those get in front of you while you were with the court?
People can request review of their cases, and we take a look at them to see whether they merit full court review or otherwise. It was a regularly scheduled part of the process of the work of the Arizona Supreme Court.
Would that be appeals from decisions by the hearing panel?
Yes.
And are you currently working for the Arizona Supreme Court?
I am. I work for the court on a part-time basis. Primarily, I chair rules committees, but in addition, I sit with the court on occasion.
Were you involved in any cases on review that dealt with disclosure obligations?
There were many cases that we reviewed. We didn't always take review of those cases and publish an opinion on them, where we had to look at the issue of whether disclosure obligations were fulfilled.
In your lifetime as an attorney, did you ever supervise prosecutors?
I did. I was the, we used to call it First Assistant Attorney General. It's now called the Chief Deputy Attorney General, and that lawyer position supervises everyone in the office.
And was that, what office were you with at that time?
That was the Arizona Attorney General's office. I was the Chief Deputy.
And have you ever been a public defender?
Sort of. I worked for a law firm when I was just out of law school that had a public defense contract in the Phoenix City courts, and I handled that contract for the office.
And you've been disclosed, you're aware that you've been disclosed by the State Bar of Arizona as an expert in this case, correct?
I am.
Okay. Are you being paid a fee for your appearance here?
No,
Are you being reimbursed costs?
I am. I care for my, now just my mother, but I have to hire somebody to stay with her because she has dementia.
And what information have you reviewed in preparation for your appearance here today? Generally.
Very large stack of the complaint, the answer, disclosure statements, motions for summary judgment by each side. I think those are the primary categories of materials.
Did you review any of the body cam videos?
No.
And why not?
My job is not to judge the facts here. That's for the fact finder. My job is to give opinions on the law.
Did you review any pleadings from other cases that might be pending in the state or federal courts?
I did not.
Would that be for the same reason?
Yes.
Your Honor, although she's been disclosed as an expert, I think technically I'd like to offer her as an expert. I'm not sure if we still do that process.
Well, I think that goes back a ways, but
Well, I'm old too.
do you have any challenge to Justice Birch's expertise?
None whatsoever. I'll join in the chorus.
All right, well, you're an expert now.
Good to know. Thank you.
And we'll let the court know that I've taken great pains to excise sections of my questions based on the court's recent ruling, and I believe, did you review that, the court's order on the testimony of witnesses?
I did. You sent it to me and I reviewed it.
So what I'm going to do now is just take you through some disclosures that were made for your testimony. So do you have an opinion regarding whether prosecutors are obligated to comply with Rule 15.1 of the Arizona Rules of Criminal Procedure and Case Law related to disclosure obligations in criminal cases?
I do.
And what is your opinion?
My opinion is that the lawyers are subject to, all lawyers are subject to following all the rules of court and all of the rules of professional responsibility.
And so that would include Rule 15.1?
That includes 15.1, and it specifically includes prosecutors.
And what about case laws such as Brady and I never say this correctly, Giglio?
Everybody knows that those are cases that impose on prosecutors the duty to disclose exculpatory evidence. Arizona's Rule 15.1 is broader than either of those cases. It requires not only disclosure of clearly exculpatory evidence, it requires disclosure of evidence that may tend to exculpate or mitigate the seriousness of an offense.
Is it reasonable for a prosecutor to rely on information provided to him or her by police officers at the initiation of a case? For example, at the grand jury stage?
Sure. In fact, that's a fairly common practice. It's what happens. Is it a best practice? Not necessarily, but I acknowledge that it happens, and that complies.
So does a prosecutor have a duty to continue to disclose evidence and to evaluate the merits of the case as the prosecution continues after the grand jury stage?
Absolutely, yes.
And what would that entail?
Well, it could entail a lot of things, and it's an obligation that emanates from several of the rules. The obligation would entail the duty to take a look at the case as it develops. You know, cases are often filed civil and criminal, and you don't just stop on the work you did when you filed a civil complaint or when you sought an indictment at the grand jury or filed a charge. You have a continuing duty to take a look at the evidence as it comes in. You have a continuing duty to look for more evidence if that's part of your job, but certainly to review the evidence that comes in, and if it discloses serious problems with your case, you may then have an obligation to disclose that to the defense. You may have an obligation to talk to your supervisors about whether it's prudent to proceed with prosecution of that case, and you may ultimately have a duty to dismiss the case.
Do prosecutors have any heightened duties because they're considered ministers of justice?
They do. All lawyers, of course, have general obligations to follow the rules of ethics. Prosecutors have a specific duty under Rule 3.8. The comment calls them ministers of justice and specifically notes their duty to the administration of justice. And it stems from the notion that prosecutors are supposed to represent all of us. They're supposed to represent society. They're supposed to be the best of us, and we count on them to be honorable and to help facilitate the administration of justice.
Would that be especially true in a case in which there's a unique charging theory that's never been used before by the county attorney's office, such as assisting a criminal street gang?
I think so. There's nothing specifically that says this, but prosecutors wield a lot of authority. They, simply by bringing a charge, they have the power to damage a person's reputation, ruin their lives, make them nervous, make them have to hire lawyers, may jeopardize future job opportunities or future educational opportunities or future military opportunities. So it's a very weighty power that the prosecutors hold. So when you're looking at bringing a new charge that takes what otherwise might have been a relatively small charge, like a misdemeanor charge, and bumps it up into the felony range, you're now taking the case out of the city court system and you're putting it in the superior court system. You've greatly expanded the range of sentences that may apply, and a prosecutor should be very careful in doing that.
And does the failure of a prosecutor to do so present problems or issues with the case? For example, a remand?
Well, it could. It depends on what the failures were. Sorry, that's a little bit difficult to answer in a vacuum.
And it was poorly asked, so good effort. I appreciate that. Let's move on to the next disclosure.
Sure.
Do you have an opinion regarding whether, as a minister of justice, well, let's not, because I just asked that.
Okay.
We're good. See, Judge,
Good job.
I'm trying, Judge. Let's go to, do you have an opinion regarding the lack of cooperation with other law enforcement agencies and whether it obviates a prosecutor's duty to comply with disclosure obligations such as Rule 15.1?
Prosecutors do have an obligation under 15.1 to disclose evidence from people who are sort of under their control. And I think the quibble here is how far does that duty go? The cases that exist in our system right now don't seem to be clearly on point. That is, a lot of them deal, as in forward with entities like the FBI that are clearly not under that prosecutor's control. The thing that's slightly different about this case is that the charge in count one appears, and again, these are factual questions that the fact finder is going to have to determine, but it is charged that that case is based upon evidence that was put together by what seems to have been a joint working group. And again, that's for the fact finder to ferret out. But in that case, it seemed as though the prosecutor was able to get information to the federal agency and to get information back from the federal agency pretty much at will. And again, it's for the fact finder then to determine whether there was that degree of control and cooperation that would have made that a mandatory disclosure obligation back.
And the fact that an agency may make it difficult for a prosecutor to get information to be disclosed, again, doesn't obviate their duty to try to secure that.
In my opinion, that's correct.
Do you have an opinion regarding whether a prosecutor may continue prosecuting a defendant in the absence of probable cause, or if they learn there is insufficient evidence to support the charges?
I do, and that is that the prosecutor shouldn't continue to prosecute a case where probable cause falls away, or even if there come to be really serious concerns about whether the prosecutor can make his or her case. And this is supported by many of the rules. 1.1 dealing with competence, 1.3 dealing with diligence, 3.1 bringing meritorious charges, 3.3 again expedition. The list goes on, but the rules impose a continuing duty to review your case. Actually, 3.8 is very strong in this point. 3.8 talks about prosecuting a case. It doesn't say initiating a charge. It talks about prosecuting a case. There has to continue to be probable cause. 3.8 A or 1, it's right up at the top of 3.8. So there are a lot of rules that impose a continuing obligation on the prosecutor to take a look at the facts and to prosecute only those cases where probable cause continues to exist.
And that answer may dovetail into this next question, which is, do you have an opinion regarding whether prosecutors must diligently perform all reasonably necessary preparation for the representation or for the prosecution?
I do. The rules themselves use almost those particular words to impose that requirement.
And do you believe that all of those rules apply to prosecutors in addition to 3.8?
Of course they do. The preamble to our rules says that these rules apply to all lawyers, and that would include prosecutors. And we have cases where prosecutors have been disciplined for failing to disclose evidence and so forth.
Do you have any concerns about a prosecutor who overcharges?
I have concerns about any government entity that overcharges, yes.
And I think you touched on it earlier, but with respect to defendants facing criminal charges, do you have any particular concerns about overcharging?
Yes, of course. I think government has a heavy duty to wield its power with grace and competence. I mean, it has the duty to protect the public, yes, but this power shouldn't be used like a sledgehammer. It should be used to charge the appropriate charges and then let the defendant defend against appropriate charges.
Should it be used to send a message to the public at large?
That's a harder question if you think there are going to be scads of new cases coming along that may deal with that particular situation. Generally speaking, the rules require, and I think justice requires, that you deal with each defendant individually, take a look at the circumstances relating to that individual, and charge accordingly.
Cross-examination?
Yes, thank you, Your Honor. Good morning, Justice Birch.
Good morning, Ernie.
We've known each other for a while, haven't we?
We have.
In a very positive way, and thank you for your kindness when we deposed you. Relative to your testimony today, how would you define overcharging?
It's not actually a term I used.
This is in response to your question about overcharging.
Sure. So I'll tell you what I understood the term to mean. When there is a criminal action, there are usually certain charges that seem naturally to flow from that, whether it's a murder, an assault, or whatever. There are charges that flow from it. There are often a range of subcharges that could be brought, and oftentimes are brought for plea bargaining purposes, but sometimes the thought there is that they'll fall away. I think it gets to be overcharging when far more charges are brought than are necessarily supported by the evidence, where the likelihood of a guilty conviction on one or more would support the kind of punishment that seems appropriate to the prosecutorial agency in a case. Other than that, it's hard to define, but that's the way I understand the term.
Let me ask you a question on that. You brought up an interesting point. You testified that the punishment needs to be appropriate to the prosecutorial case. What does that mean?
Well, you don't get to punishment, of course, until you get through with all of the discovery, you get through the trial process or a plea process. In our system, we look at each defendant as an individual, and we look at the conduct that the person has engaged in, and we attempt to craft a penalty that's suitable to the crime as punishment for the crime and to the individual.
You testified earlier that you were, at least it was under your watch, that the current lawyer's professional responsibility oversight was changed, correct?
Correct.
In regard to that, did your committee talk about the purpose of attorney discipline?
Of course we did.
And was punishment part of that?
Not really. It was certainly discussed, and it was certainly mentioned, but the primary purposes are to protect the public and to correct the respondent attorney, to get them back on the right road.
You testified, Your Honor, that you were the chief deputy attorney general.
Yes.
I'd like to ask you about the chain of command
Sure.
during that time frame. Who was the attorney general at the time?
Grant Woods.
And where did the buck stop?
With General Woods.
With General Woods. And if General Woods gave you a directive that you needed to pass down the chain of command, did you expect those directives to be followed?
Your Honor, I'm going to object for relevance, and it seems to be outside the scope of the purposes for which the justice was disclosed, as reflected in your order on the testimony of witnesses.
Well, there are multiple objections there. I will say that I was somewhat expecting an objection to the earlier question, because I did specifically state that expert testimony about the purpose and history of the attorney disciplinary process would not be admissible. And so I'm certainly not thinking that the door has been opened to change that ruling. And so there was no objection to that question, but there's an objection to the pending question. What are you trying to elicit at this point, Mr. Calderon?
You know, Your Honor, in order to save time, I'll just move on.
All right, that's fine with me. Thank you.
Trying to respond to the bar's questions, so I'm moving a little bit haphazardly, and I apologize to the witness and the court as I delay. I want to understand, Your Honor, your answer when you were discussing your answer to Ms. Schumann's question when you were discussing Rule 15.1. She asked you something about prosecutors being ministers of justice, and then talked about Rule 15.1. And then I think she said, how far does that go? And your response was, it's unclear. Could you explain that to me?
Yes, it's even unclear from your question. I don't know how far does that go, whether you're talking about Rule 3.8 or 15.1.
I'm just in response to your answer. I'm trying to find out what you meant in your answer.
I don't remember precisely what my answer was. So how far does what go? If you can pinpoint that, I'll attempt to answer.
I wish we had a court reporter. I could ask it to read that back. I would assume it was in response to Ms. Ms. Schumann's reference to Rule 15.1, and Ms. Schumann, do you recall the question that you asked?
Yeah, I think you just have to rely on your recollection. I don't remember exactly what the context was either.
When you did the revamping of the lawyer disciplinary process, did you have a discussion about having a court reporter present?
Objection.
Sustained.
Thank you. Your Honor, you testified that, I think you testified that in this case, the prosecutor was able to get information from a federal agency at will. Do you recall that answer?
Yeah, I think it was a little more nuanced than that. There is information in the charging document that information, and in the motion for summary judgment that not sure about the motion for summary judgment. There was information in the record that at one point Ms. Sponsel asked for information and was able to receive a letter back from a federal agency in 2 days, which in my experience with federal agencies would be some kind of a record.
So that's the basis for the at will, receiving information at will.
That's what I have seen in the record, but again, that would be for the fact finder to judge.
Your Honor, you testified to about ethical rule 1.3.
Mm-hmm.
I'd like to focus on that just a little bit.
Sure.
Ethical rule 1.3 talks about reasonable diligence and promptness in representing a client. As one of the authors of the new system, or the system, I'm an old lawyer, so I'll just call it the system. What does reasonable diligence mean as it relates to ER 1.3?
Yeah, the word reasonable is used throughout these rules, and in some aspects the rules are sort of precatory or hortatory, and they seek to encourage the best possible practices, and in other areas they are sort of bottom level limits which you can't go below. So what do we mean by act with reasonable diligence? I think we meant do those things that an ordinary lawyer in that position would do to pursue prosecution of a case, whether that be civil or criminal. I also note that comment under Rule 1.3 says it's no excuse if you think you're really busy. You have a duty to either get yourself unbusy or bring it to someone's attention that you need help.
Does reasonableness have any relationship to the complexity of the case?
Of course it does, but it may not be the one you expect, which is that if the case is really complex or you're trying out new theories, it may impose upon you a heightened duty to get busy and do your work.
Would it have any relationship to the posture of the case? In other words, the point in time of the case?
It's just a continuing duty that goes on all of the time. It's not something that you can say that, okay, there's now an indictment or there's now a charge. Now I can rest for a while and not look at any of the evidence. As the evidence comes in, I can see waiting and gathering evidence together and then looking at it.
Of evidence that a prosecutor might have to analyze.
Yes, but once again, the volume may indicate that you just really need to dive in right away and start plowing through it.
What does a lawyer do if a client, in order to be reasonable, it requires a lawyer to do extensive work to the exclusion of eat, sleep, etc. But the client doesn't want to pay for that. I mean, is there anything, that's just an example, is there anything that tempers a black letter definition of reasonable?
Yes, of course there are things that would temper it, and that's why we use words like reasonableness. We don't put in absolute requirements. I do note that we're dealing with a public entity here, so payment of a prosecutor is not at issue.
The question wasn't about the current case. Comment 5 to ER 1.1 talks about adequate preparation. How does reasonable diligence affect adequate preparation? Are they interrelated?
I usually think of Rule 5 in terms of supervision and so forth. Can you give me your question one more time, Ernie?
Well, yeah, I'll ask it really quickly. Does the definition of adequate preparation have anything to do with your definition of reasonable diligence? Are they interrelated?
Well, adequacy is a determination, I think involves a determination of reasonableness, so I think they are intertwined, if that was what you were asking.
You just raised ER 5.1 et cetera, whatever, supervision. If a lawyer is overworked, does a lawyer have a duty in a public agency to report the need for additional help in order to be reasonably diligent or adequately prepare?
Sure, that actually is more of an obligation under 3.1 or 3.3. So if you're extraordinarily busy, it's not an excuse to your duty to prepare. What you do about that may depend on the kind of firm that you're working in.
Does a supervisor, since you referenced ER 5.1, does a supervisor have any duty to assess the reasonableness of a request for additional help?
Yes.
And would the supervisor have that duty as well if the request was forwarded up the chain?
If that is their chain, yes.
Up to the point where the buck stops?
It would seem so, yes.
I'm going to refer you to ER 3.2. And this is another reasonable efforts question. It's my understanding this rule presupposes compliance with existing statutes, case law, etc. Correct? No?
Yes, I assume so.
Okay. Whose duty is it to ensure that a staff lawyer complies with existing statutes, case law, and rules?
The staff lawyer.
And is there anybody else that has a duty, or does it just stop with the?
No. There's an oversight duty of supervisors, of course, but it is each lawyer's duty to make sure that the individual lawyer complies with the rules.
Comment 1 to ER 3.2 discusses how a competent lawyer acting in good faith would have some substantial purpose other than delay. What does that mean?
We're talking about expediting litigation, and we don't want people to have a purpose in slowing down a case. Sometimes criminal defendants seek to delay a case for particular reasons. They're running for political office, or they don't want news to get out, or they think a change in administration will change things, or they think somewhere down the road more evidence will come in that will benefit them, or a tide will turn. So you have a duty to expedite cases, and things can happen to delay it. We understand that, but you shouldn't delay it just for the purpose of delay, nor should you delay it for any purpose to harass or create problems for the other side, particularly our prosecutors who, again, represent all of us.
What about delaying it what about a prosecutor delaying the process in order to protect the life of a defendant in a case?
Objection, relevance, and outside the scope.
Well, here's my problem. I thought my order was clearer than perhaps you all thought it was. I greatly respect Justice Birch's experience, but we know how to read and apply the ethical rules. So I'm concerned that you're going into areas the State Bar did not choose to examine Justice Birch about, and I foresee that causing a problem later on because I've issued pretrial rulings that are supposed to limit our experts' testimony to matters that are beyond the ken of the hearing panel, which I'm not finding this to be. So I'm going to sustain the pending objection.
Your Honor, I asked for some instruction. The witness testified to several ERs. My questions involve the ERs. Is it the court's instruction that I refrain from entering that area?
No, but it's my instruction that your pending question goes far afield from the issues that the hearing panel needs assistance from an expert regarding.
Your Honor, I thank you for that explanation, and with your help, Your Honor, I'm not intentionally trying to go beyond the scope, but if you see that I am, I welcome the court to give me a gentle, perhaps, admonishment.
Trying to do that, yes.
Thank you, Your Honor. Based on your supervision duties, where you supervised, I guess, criminal prosecution, you supervised the criminal division, I guess, of the Attorney General's office, correct? That's what you testified to?
That and every other division, yes.
Thank you for that service. Is every prosecutorial error a violation of an ethical rule?
No.
I'll refer you to ER 3.8, which you raised. 3.8A talks about refraining from prosecuting a charge that the prosecutor knows is not supported by probable cause. Does that sound familiar?
Yes.
Okay. Is probable cause the same thing as a reasonable likelihood of conviction?
Let me just back up one step. It talks not just about initiating a case that the prosecutor knows there isn't probable cause for. It talks about prosecuting the case, which is a continuing stream of activity. So the prosecutor has to be aware of the evidence coming in and continually reassess to ensure that there still is probable cause, which is a legal term that's defined and used in criminal cases regularly. So a prosecutor would know